All right, let's be on the record in case number 2019 CR 538, captioned State of Kansas versus Mickey Blevins. Would the parties announce their appearances, please?
May it please the court, Candace Alcarez appears on behalf of the state.
May it please the court, Gary Long appears on behalf of the defendant, who is also participating in this call via phone.
All right, we are here set down for the defendant's motion to set aside his plea and vacate his sentence. The record should reflect that back on February 4th, the parties appeared in front of the court for the third time on a plea setting. And at that time, the defendant entered his plea of guilty per the agreement with the state. A PSI was ordered. Sentencing was set and was held on March 6th. And at that time, following that, on March 20th, Mr. Long entered his appearance, filed a motion to vacate sentence and withdraw his plea. He amended that motion on March 23rd, and we are here for that motion today. Mr. Long, how do you wish to proceed on your motion? Statements of counsel? I know that you issued a subpoena.
Your Honor, I did issue a subpoena and apologize. I misspelled the ADA's name. Candace Alcatraz, that is. Your Honor, we can I don't know how much evidence you'd want to have. The basis of the motion is that the defendant was never provided any discovery and would ask the court to take judicial notice of the filings in this case. It doesn't appear this trial counsel ever requested discovery and was never received discovery and never reviewed evidence in this case. And my hope would be is that the ADA would provide basically would stipulate that Mr. Russo also did not come review the evidence that was contained in her file. And that's the basis of the motion. I know that there were 3 plea hearings set in this case, but at no point was Mr. Blevins provided any of the evidence against him, and it doesn't appear that his attorney received it, and therefore we're asking the court to set aside the plea in this case.
Well, I noted in the record that back on June 21st, when Mr. Blevins had his original appointed counsel, there was a discovery receipt actually on the 21st of June and the 28th of June of last year. Did anybody make any inquiry as to whether Miss Erickson, when she was relieved, passed on her file to Mr. Russo?
I didn't, Judge.
Your Honor, I didn't either. It was my understanding that wasn't allowed, and as defense counsel, we're agreeing not to do that. And I don't know if it's a, that we weren't, we aren't to provide that discovery to new attorneys in the case. So I don't know if that happened.
What's the rationale behind that? I'm not quite clear.
Well, there was an incident with another case where one attorney said he passed off discovery to another, and then a case almost got, well, supposedly almost got dismissed for that discovery not being turned over, even though the state was told, I'm turning this over to somebody else. So
all right.
From there on, that decision was made that everybody just get new discovery.
Okay, so what you're asking the state to agree on is that they don't show any request by Mr. Russo for direct access to their file or the discovery documents thereof. Is that correct, Mr. Long?
Yes, Your Honor.
All right, and Ms. Alcarez, do you have any knowledge to the contrary of that?
Judge, I'm looking in my system and I don't see one from Mr. Russo. I do see one from Ms. Erickson, like you said, back from June.
No. All right. Mr. Long, anything else on behalf of your motion today?
No, Your Honor, I would, if I were to call my client, it would be simply that he was never provided, and the basis of the motion is the fact that the defendant, counsel never obtained discovery and never reviewed it with the defendant prior to entering a plea in this case.
All right. Who's arguing? I assume Ms. Rayler's here in case people thought that Ms. Alcaraz would have a conflict, but that doesn't seem to be the case. Am I correct in that assumption?
Yes, Judge.
All right. Mr. Long, do you have any objection since Ms. Alcaraz really isn't a material witness, given everybody's agreement as to that issue with her arguing this case?
I have no objection to that, Your Honor.
Ms. Alcaraz?
No, Judge.
No, please,
Oh.
with your argument.
Oh, Judge, I would stand on my motion. At no time during the plea hearings did he say anything about him not looking over discovery. The judge went through everything with him, and in fact, we set it over so that he could have more time to do that. So him not having his discovery or him saying that they never reviewed it together, that is news to me today. But nonetheless, I would stand on my motion.
All right. All right. Well, I will tell you that prior to coming on the record, over the weekend, I reviewed the transcript of the waiver of preliminary hearing and the plea. And I don't know that there is a more clear record made in any particular case that the defendant understood exactly what he was doing. He had the opportunity at that time to complain about any deficits of his attorney. And in fact, he indicated he had no complaints regarding Mr. Russo. At the end of the hearing, the state was requested to place a factual basis on the record, which they did, ticking off each and every one of the elements that would be required for them to prove the counts that the defendant pled to. At the end of that, the court inquired of the defendant whether in fact that's what happened, and he affirmed that that's what had happened, thereby admitting his guilt. I understand that in his new motion, he's maintaining his innocence. Look, the record is completely solid that the defendant understood all of his rights at trial, understood exactly what he was giving up, and indicated his desire to do so, his satisfaction with both the court process and his attorney, and then he admitted the guilt in this case. If we were pre-sentence, I'm pretty lenient on letting people do that, but the law is pretty clear that once they are sentenced, that they have to show manifest injustice to allow their plea to be withdrawn. And look, if I assumed for the purposes of argument today that Mr. Russo didn't have his discovery, didn't go over the case with the defendant, and didn't do all of those things that the defendant now says he didn't, that he was given the opportunity to complain about that, to inquire about that, and not give up his rights and not go forward plea. And in fact, he had an attorney prior to that. That was appointed to him. It was set for a plea then. He then retained Mr. Russo and continued it again for another opportunity to consult with Mr. Russo before making his plea. So I don't have any doubt that it was freely and voluntarily given, that he understood what he was doing. I really don't have a position as to what he and his attorney did with any discovery, whether they had it, went over it or not. But the defendant freely, voluntarily entered this plea. He's failed to make a case for manifest injustice today to allow him to withdraw that plea. So I'm going to deny his motion. and leave the sentence in place, leave the plea in place. Mr. Long, I don't know if you plan on appealing the court's ruling today or not, but you know your statutory time, and I would ask you to discuss that with your client and make the appropriate thing. I just want to make sure that your client's advised of his right to appeal that today. All right. Other things we need for our record today.
Not from the state judge.
All right. And Mr. Long, your motion, will you journalize, share it with the state and then e-file it for my signature?
Yes, Your Honor.
Appreciate it. All right, Mr. Blevins, good luck to you. I hope you keep in touch with Mr. Lindstrom. I know that it's a little bit difficult now with the pandemic and all that, but I'd like to see you talk to him more than you do the Kansas City, Kansas Police Department, okay?
Yeah.
Yeah.
Yes, sir.
All right, we're adjourned.